Excuse me. Okay, here we are back at the American Bar Association Model Rules of Professional Conduct. As I said before, these are basically federal rules, and they apply to every court. And I was telling you how some states decided to remove parts, which is illegal. Okay, so we're going to have to go back to the modern rules of professional conduct. Okay, I read to you in the other one part of the preamble. You should read the whole thing. It's beautiful. It's beautiful. Okay, what I wanted to go over is Rule 3.8. Okay, see right there. Special responsibilities of a prosecutor. Now remember, I told you before, it's impossible to just violate one rule. When you violate one rule, you violate multiple rules. Okay, Rule 3.8, if they violate special responsibilities of the prosecutor, they violate Rule 3.4, fairness to the opposing party, and if you're not in a criminal case and you're in a civil case or otherwise, then you'll specifically want to use Rule 3.8, fairness to the opposing party, and if there's no fairness to the opposing party, it's usually because of meritorious claims and contentions, which often people file suit that have lack of meritorious claims and contentions. And people know them in civil court as slap suits. But if you go over meritorious claims and contentions, you'll find out that slap suits can't exist because people will threaten to sue or lose lawyers to sue you. So then you'll have to get a lawyer. But if you knew the rules of professional conduct, you would know that they can't state claims. They can only state meritorious claims and contentions. And so if they just drag you into court, it's something they can't prove, or you need a lawyer and you can't. But if you go here, it'll tell you that they can't. That's legal harassment. They can't just go in there with Facebook memes, thoughts and feelings, heartfelt prayers. No, there has to be something substantial for it to move forward into a court of law. Before a lawyer should even consider taking a case to court and suing someone, there must be meritorious claims and contentions. Otherwise, it's just legal harassment. Evaluation. Okay, lawyers serving. So, they often. It's impossible to violate one law. Okay, diligence. A lot of lawyers, I get through with them because I mentioned to them down here is expediting litigation. It's mandatory to expedite litigation. It would be diligent. Over here, 1.3, it would be competent. 1.4, failure to do so would be what? If you're not competent, that's what? Incompetent. Okay, so failure to be diligent is a failure of competence. Confidential information, failure to do that, which lawyers often do. Confidential is a failure of competence. So you can mix and match and choose. If you violate one rule, you'll violate another. And no matter what court you're in, like look down here. Podcasting, voluntary pro bono public service. I don't say why they say it's voluntary when it's mandatory. If it's in the rules, it's a law. Accepting appointments. Lawyers shouldn't accept appointments if they're not going to abide by the rules of professional conduct. This is the law. These are laws, people, okay? So learn to use them. Okay, and a lot of people complain that lawyers don't do this, and I said, well, there's something you can do about it. I've been trying bar admission, discernment, judicial legal. Okay, reporting professional misconduct. Okay, that's mandatory. Misconduct. So violating any of those rules is misconduct. Okay, so you want to, I'm going to go over Rule 3.8 Not abiding by that is misconduct. And reporting professional misconduct is mandatory. Failure to report professional misconduct. Somebody's watching my other videos. Reporting professional misconduct is mandatory. Failure to report misconduct is misconduct, which is a lack of diligence. Failure to communicate. Communication is mandatory, not just with the client, but with everybody else in the courtroom. It's just impossible to violate one rule. So we're going to go through to Rule 3.8 because I notice this is the one that that's been, wrong one. 3.8. It's been removed from a few states. Okay, so this is law. Okay, I've been using this for years, but I've been shot down by the courts, from local to Supreme Court, and they just rubber stamp whatever happened to me, and especially when they don't like that I cite every law possible, because when I cite the violations of the rules of professional conduct, I don't really do that. I mention how it's unethical, and it's a violation of every ethic the legal community is responsible for. So but there's no ethics in a court of law if nobody's abiding by the rules or the codes. All right. Prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. You know how many times I try to help people in criminal court, and the first thing I push for is a probable cause. Public defenders don't like it. State's attorneys don't like it. Judges especially don't like it. I've only seen one judge on the internet, and he's actually the one pushing for the probable cause. Nobody else, him. Okay, refrain from prosecuting a charge prosecutor knows it is not supported by probable cause, and that's true in any court. That's in civil court, it's called a slap suit. Make reasonable efforts to ensure that the accused has been advised of the right and to procedure for obtaining counsel and has been given a reasonable opportunity to obtain counsel. Not to obtain from an unrepresented accuser waiver of important pretrial rights, as is the right to a preliminary hearing. And even upon arrest, you ask for a lawyer, and it's happened to me, it's happened to other people, where the cops bring a lawyer in and happens to be assistant state's attorney. So be careful who you talk to, people. Be careful who you talk to. And remember, anything you say can and will be used in a court against you. And there's no evidence supporting what they say is true. But in any court of law, public servants will take the side of public servants before they will we the people. Okay. Make timely disclosure. And that rarely happens. I've been denied disclosure no matter what court, no matter what lawyer I had working for me, against me. Remember, making timely disclosure is not just mandatory from your attorney, but from the opposing party. And if not, cite the judge, tell the judge, hey, nobody's giving me, discovery. Why is nobody giving me discovery? It's mandatory. Make timely disclosure. And a young lady told me the judge got upset because nobody gave it to her. He went and got it, came back and threw it on the floor in front of her over the bench. People, seriously, judges and lawyers get upset when you bring up their job description to them, their constitutional duty as well as your constitutional right. These are your constitutional rights. Get used to them, read them, know them. You want to be an influencer, use the law. Make a timely disclosure of all, to the defense of all evidence or information known to the prosecutor that tends to neglect the guilt or the accused or mitigate the offense. And in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigation information known to the prosecutor, except when the prosecutor is relieved of the responsibility by protective order of tribunal. Okay. So F. except for statements that are not necessary to inform the public of the nature and extent of the prosecutor's action that serve as a legitimate law enforcement purpose, refrain from making extrajudicial comments that are substantial likelihood to highlighting public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making extrajudicial statement that the prosecutor will be prohibited from making under Rule 3.6 for this rule. Now, this is the main part I want to get to. I want you to get to, because a lot of people ask me, can you help me find a lawyer because I have exculpatory evidence and I want to overturn a wrongful conviction using that? Well, let's go here. When a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall properly disclose that evidence to appropriate court authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to defendants unless a court authorizes delay. Further, undertake further investigation, make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense and the defendant did not commit when the prosecutor knows of clear and convincing evidence that a defendant in the prosecutor's conviction was convicted of an offense the defendant did not commit. The prosecutor will seek to remedy the conviction. So if your lawyer's not telling you, hey, let's just take this all to the prosecutor's office and let him do all the work, that way I can't hit you with all these billable items. I mean, if there was any honesty, integrity, ethics in the lawyer you're speaking to, or any lawyer otherwise, and they're not discussing this. I often tell people when it comes to public servants, nobody wants to work. Nobody wants to do their job, okay? So that's what I want to use. I have a ton of exculpatory evidence in one case. And actually, my lawyer told the judge I was going to go out there and have the judge cite them for violating the rules and the code of rule of professional conduct. I was citing them, not directly, but indirectly. The failure to give me a quick and speedy trial, which is their statute of limitations, 90 days. This went on almost a year before they even granted me a trial. When I started citing that I wanted discovery, disclosure is mandatory, and I was denied it. I have the transcripts, even in the transcript, The state's attorney, they couldn't prove the case. The injuries the plaintiff was claiming could easily be disproven with the hospital reports, but nobody would show them to me. Nobody would give them to me. I was sued in the same manner. And insurance company, they got a declaratory judgment as well as a summary judgment, and saying they didn't have to pay for my attorney, so I had to go pro se. The attorneys handling the case through the insurance company, they said they weren't going to give it to me till I got a lawyer. I raised a ruckus, and they finally gave everything to me. And, so I found in the hospital reports that everything contradicted what was testified in court. Everything. It showed, and plus in the preliminary hearing, I don't know why the judge didn't cite her for perjury. It was my ex-fiance, made false accusations. And he told her she couldn't say what she said because it's not in the hospital reports. He says, you're lying. Who told you? She said, the doctors. What doctors? She mentioned the hospital. He said, it's not here. I have it right here. I strongly advise you not to say this again in court. You'll be cited for perjury. He let the case continue. It went on to trial. He had cited her for perjury right there and then. I wouldn't have went through what I went through. I had the life beaten out of me. My lawyer ran out and told the judge that I said that reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct, and he ran it out there. And I told him, yeah, failure to report misconduct is misconduct, and I wasn't allowed back in court. Took me down the elevator, through the tombs, and went back when they got me back in the county jail. It beat the life out of me. Tried to break every bone in my body and crush my skull. Okay, so that's special responsibilities of the prosecutor. So they violated that. They violated 3.4, 3.5, impartiality and the decorum of the tribunal. And like I said, reporting misconduct is mandatory. Reporting professional misconduct, Rule 3.8. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct raises a substantial question as to the lawyer's honesty, trustworthiness, and fitness as a lawyer, and other respects shall inform appropriate professional authority. A lawyer who knows that a judge has committed a violation of applicable rules of the judicial conduct that raises a substantial question as a judge's fitness for office shall inform the appropriate authorities. The rules do not require disclosure of the information otherwise protected by Rule 1.6 or information gathered by a lawyer or a judge while participating in approved. Once the rules of professional conduct are violated and nobody reports, the judge is legally required to report any violations of the rules of professional conduct. The judge's failure to report misconduct is misconduct, and that's in the code of judicial conduct. So when the rules of professional conduct are violated, so are the code of judicial conduct. And the same with the code of judicial conduct as the rules of professional conduct. The code of judicial conduct, it's impossible to violate one canon without violating multiple canons, and the preamble, the scope, just as well. And this is the law. This is due process. Okay, so it's so reporting misconduct is mandatory. Reporting professional misconduct. Professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowing or assist or induce another to do so. The acts of another commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer, or other respects, engage in conduct involving dishonesty, fraud, deceit, misrepresentation, engage in conduct that is prejudicial to the administration of justice, state or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate the rules of professional conduct or other law. Knowingly assist a judge or a judicial officer in conduct that is a violation of applicable rules of judicial conduct or other laws. Engage in conduct that the lawyer knows or reasonably should know that is harassment or discrimination on basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in the conduct related to the practice of law. This product does not limit the ability of a lawyer to accept, decline, or withdraw from representation in accordance with Rule 1.6. This paragraph does not preclude legitimate advice or advocacy consistency with the rules. I'm not giving you advice, I'm just giving you the law. Misconduct. How often doesn't that happen? If you watch anything about politics, the law, the Supreme Court, any cases going on, you should look this up, print it out, copy it, highlight it, whatever issue, and sit back and watch how often this doesn't happen. Reporting misconduct. I told you what misconduct is. So you know reporting misconduct is mandatory. Who's doing that? Who's doing that? I've been doing it since the 80s. And I've been totally ignored, shut down. I'm surprised I got answers from the people that I did. There's a lot here you should know. And lots of times they'll tell you, hey, that don't mean what it means. What you think it means. Look at competence. This is all you need. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. So, not only does this prove ineffective assistance of counsel when not doing any of this, it proves the ineffectiveness of the court. So people complain, oh, crooked lawyers, judges, you know, if you want to, you know, take that, you know, license to practice law away, use the law. The rules of professional conduct, the code of judicial conduct. That's the easiest way to take down, you know, professional misconduct. You know, in the world of profession, there's always professional misconduct. Okay, so that's the modern rule of professional conduct. Okay, remember I told you the American Bar Association's model rules of professional conduct are a set of rules, communications of ethical and professional responsibilities of the member of the legal profession in the United States. All right, God bless people. I'm trying to make these as short as possible, okay, because YouTube only allows 1 hour and a lot of other places. 3 minutes max. How can I explain this in 3 minutes? I'm doing my best. And remember, this isn't the only important thing you should know. You know, there's a whole lot of stuff that it's important for you to know. And it's in all my other videos. I have one gentleman working very, very hard, vigorously, through all my posts. And he knows he can't use everything, but he always finds something he could use. And he's citing for violations of rules of professional conduct, code of judicial conduct, ethic violations, where to file these ethic violations. When you want to file for violations of rules of professional conduct, just type in rules of professional conduct complaint form. Okay, code of judicial conduct complaint form. And since they work together in conjunction, they were in cahoots of depriving you of your constitutional right to due process, a fair trial. Again, that's contingent on effective assistance of counsel, and if effective assistance of counsel isn't happening, and it isn't. It never happened for me. A lot of you I talked to, it didn't happen for you, and I'm trying to teach you the easiest way to get it. Okay, so remember, this is a conspiracy against rights under the color of law. Okay? Okay, conspiracy against rights under the color of law as defined in 18 U.S.C. S241 and 18 U.S.C. S242 involves two distinct but related offenses. Section 241 prohibits conspiracy to injure, oppress, threaten, or intimidate individuals in free exercise of employment of their constitutional or statutory rights. Section 242, on the other hand, criminalizes privation of these rights by anyone acting under the guise of law, regardless of whether they are acting within or beyond their official authority. Criminal Rights Division, statutes enforced by the Criminal Rights Division. Conspiracy against rights. Deprivation of rights under the color of law. Conspiracy against rights. So if you want a better understanding of what I'm talking about and everything I've been talking about, you'll actually want to look this up, conspiracy against rights. But right now I'm talking about nobody enforcing the rules or the codes. And so that just proves that they're working in conjunction. And since they're working in conjunction in courts, there's more than one person working against you. Deprivation of rights. And under the color of law, you just think it's legal because they did it to you in a court of law, but they didn't actually use the laws, the actual law in a court of law. So, all right, nothing but love for you. Okay, when it comes to you, all of you, as the law requires. It's a matter of self-imposed ethics. But when I see you, all I see is we the people, fellow citizens. And I won't judge you by your words. But I will judge you by your deeds. It's not what you say, it's what you do. I've been calling out public servants for so many years. I could use your help. And I'm showing you a whole lot of stuff I've been using, okay? My life's been threatened so many times, left for dead. And I even had a threat made to the bloodline, immediate family members, parents, siblings. So I had to stop doing what I did for me. But that didn't stop me what I was doing for we. Listen, I've been helping a lot of people for a lot of years, okay? So I'm going to start up in my next video, put my head in the noose again, okay, and go over my personal issues, okay? Starting, it was a conviction and I got sued. I won the lawsuit, but I lost the criminal case and I won the lawsuit on a pro se motion. That doesn't happen. I mean, it happened for me. But, it's when I got the lawyers out and brought the law with me is when they capitulated. What I did for me, you can do for we. That's not what you can do for your country. That's what you can do for we the people. Because what you do for we the people, you do for yourself. What they took from one, they took from all. And people, you're finally starting to realize that. People are finally starting to realize that. So together we can get it all back. Alone, my voice is like a church mouse during choir practice. Together, as a lion roars, I will be heard. Who am I? I am we the people. I am many. We are one. Dedicated my life to this. Lived for it. Still willing to die for it. Not but love. Peace be with you.